55th Circuit Court is now in session. The Honorable Roy G. Meeks presiding.
May be seated. Calling the cases of the People versus Kyle Thomas Ackerman. Counsel identified for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
And please report Scott Moore for the defense.
You are Kyle Thomas Ackerman?
Yes, Your Honor.
What do we have on the screen there?
We have a speaker view, and he's just on the phone, so there's no video.
Your Honor, it's a notice advising people that they're being recorded. Giving them
It's hard to tell from this angle, so I didn't know if I had to press the button or something. All right, today is set as a final pre-trial. Anything? You've had some discussions with Mr. Webb today?
I have, Your Honor. In fact, we've been talking about this over the last few weeks. As I want to say, we are close to a resolution. As I've indicated, there are some guideline issues as well as eligibility for boot camp that we need to button down. This matter has been reset for jury trial in the middle of July. I would ask the court to schedule this for a continued final pretrial conference, perhaps sometime in June, and then strongly encourage Mr. Ackerman to appear in person so that we can conclude those negotiations.
All right. All right. Mr. Ackerman, did you hear what your attorney said?
Yeah.
All right. So we're going to reschedule this for sometime in June, and we're going to require you to appear in court. Okay?
All right.
All right. Anything further from either party?
I have nothing. Thank you, Your Honor.
No, Your Honor. Thank you.
All right. You're all set, Mr. Ackerman.
All right. Thank you. Have a good day.
Pleasant. He's a pleasant young man. Polite, respectful. Thank you, Your Honor.
All right. Is Mr. Middleton available?
Mr. Middleton is in the hallway, Your Honor, I believe.
Okay.
I was in the hall, Your Honor, and I was wondering if I could talk to the prosecutor last minute.
Sure. You want Mr. Webb, are you handling Mr. Middleton's case?
Yes, Your Honor.
And you're in the office building?
I am. Would you like me to come up?
Either that or Mr. Rowe can go down and visit you. Whatever your choice is.
I'll come up.
Okay.
Thank you, Your Honor.
All right.
I don't know how long we want to wait for Mr. Knapp.
I feel someone in the waiting room is identified.
All right.
Fifth Circuit Court is now in session. The Honorable Roy G. Meeks presiding.
May be seated. The case of People versus Charles Dale Middleton.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Middleton, and Your Honor, may the court indulge us by allowing me and Mr. Middleton to sit at the table.
Yeah.
Mr. Middleton, have a seat over there, please.
Mr. Webb, your appearance?
Morning, Your Honor. Mark Webb on behalf of the people.
You've had some time to talk with Mr. Webb. Anything been resolved in this case?
Yes, Your Honor. After the discussion with Mr. Webb, I presented and explained the new offers of Mr. Middleton. He wants to accept it. He'll be pleading to counts 1 and 2 according to the plea bargain offer.
All right. You are Charles Dale Middleton?
Yes, sir.
And how old are you?
32.
So raise your right hand and be sworn.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Mr. Middleton needed to talk about. They're trying to record it, so.
I'm sorry, not here.
Okay, you have any problems here?
And, Mr. Rowe, you've given, Mr. Middleton a copy of the information or you've gone over the information with him, is that correct?
That's correct, Your Honor.
Is he waiving the right to have a reading of it for today's purposes?
He is, Your Honor.
And continuing the waiver of the preliminary examination.
Yes, Your Honor.
Mr. Middleton, you're being charged with count 1, police officer assaulting or resisting or obstructing, and count 2, police officer assaulting or resisting or obstructing. Those are felonies that carry a maximum penalty of 2 years in prison and or a $2,000 fine. A consecutive sentence may be imposed if the assault was committed in a place of confinement or for another violation arising from the same transaction. Otherwise, the minimum is discretionary with the court. You understand the charges and the possible penalties?
Yes, sir.
There's one of 3 possible pleas you may make to these charges. You may plead guilty if you are guilty, but don't plead guilty unless you are guilty. You may plead not guilty, or you may stand mute, in which event the court will enter a plea of not guilty for you. You understand the one of 3 possible pleas you may make.
Yes, sir.
You're also pleading to the habitual offender third.
Yes, Your Honor. I'd be habitual third.
Then you're also being charged as habitual offender third, which means the maximum penalty could be twice that. So those charges, instead of 2 years in prison, it could be 4 years in prison. Do you understand that?
Yes, sir.
All right. Answering to count 1, police officer assaulting, resisting, or obstructing, how do you plead? Answering to count 2, police officer assaulting, resisting, or obstructing, how do you plead? Answering to habitual offender third offense notice, how do you plead?
Guilty.
Do you understand that no one may make any promises for this court as to what your sentence will be?
Yes, sir.
The court further informs you that if your pleas are accepted, you will not have a trial of any kind and therefore give up the following rights. The right to have a trial by jury, the right to have a trial in front of this court sitting without a jury, the right to be presumed innocent until proven guilty, the right to be proven guilty beyond a reasonable doubt, the right to question all witnesses against you, the right to have this court order witnesses on your behalf into court to testify at trial, the right to remain silent and not have that silence used against you during trial, and the right to testify at trial if you wish to do so and have your testimony considered in the same manner as any other person's testimony. Do you understand these rights?
Yes, sir.
You understand if I plead guilty, give up each and every one of those rights.
Yes, sir.
All right, that's an advice of rights form. It just states what I just told you. Please review it and sign it. You did it. Mr. Webb, what is the plea agreement?
Your Honor, in exchange for the defendant's guilty pleas to counts 1 and 2 as a habitual third offender, we'll dismiss count 3 and the habitual fourth offender at sentencing. And we are agreeing to a Briggs Killebrew cap of 12 months in the Clark County Jail and would not object to an inpatient treatment at the end of the jail term with day-for-day credit.
Mr. Rowe, is that your full and complete understanding of the plea agreement?
It is, Your Honor.
Mr. Middleton, did you hear it was put on the record as the plea agreement?
Yes, sir.
Did you understand it?
Yes, sir.
And are you in agreement with it?
Yes, sir.
Has anybody promised you anything beyond what was stated in the plea agreement to induce you to plead guilty?
No, Your Honor.
Has anybody threatened you or your family in order to induce you to plead guilty? Has anybody promised you that if you pled guilty, this court would be lenient upon you in any way? Is it your own personal choice to plead guilty?
Yes, sir.
And are you doing so freely and voluntarily?
Yes, sir.
Do you have any questions about what the court has told you?
No, Your Honor.
Have you understood everything that the court has told you?
Yes, sir.
In light of everything the court has told you, do you still wish to plead guilty?
Yes, sir.
Drawing your attention to on or about December 10th of 2020, were you in Hayes Township, Clare County, Michigan?
Yes, sir.
And did you come in contact with a couple of deputies?
Yes,
And one of them was Deputy Aaron Miller,
yes, sir.
and one was Deputy Bradley Feiger?
Yes.
All right. And you knew that they were deputies at that time?
Yes, sir.
And you knew that they were performing their jobs as deputies?
Yes, sir.
And did you assault them, resist them, or did they tell you to do something and you failed to do so?
Yes, sir.
You resisted them? All right. So they went to place you under arrest and you refused to let them do
Yes,
that?
sir.
All right. Did anybody get hurt during this couple?
I mean, I cut my elbow,
Okay.
but I mean, there one just got hurt.
All right. Any questions, Mr. Webb, regarding this factual basis?
No, thank you, Your Honor.
You're satisfied with the factual basis for those two charges, Mr. Rowe?
I am, Your Honor.
And is it true, Mr. Middleton, that on or about December 18th of 2017, you were convicted of police officer assaulting, resisting, or obstructing in the 55th Circuit Court for Clare County? So you have a prior resisting and obstructing conviction, is that correct?
Yes, sir.
All right. Is it true that on or about July 21st of 2015, you were convicted of a SORA violation in the 55th Circuit Court for Clare County, is that correct?
Yes, sir.
And on or about December 12th of 2011, you were convicted of a criminal sexual conduct charge in the 55th Circuit Court, Clare County, Michigan, is that correct?
Yes, sir.
All right. Satisfied with the factual basis for the third offense notice, Mr. Webb?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Rowe?
Yes, Your Honor.
Has court complied with the court rules, Mr. Webb?
You have, Your Honor.
Has court complied with the court rules, Mr. Rowe?
It has, Your Honor.
Court has not agreed upon the possible plea or the possible sentence with either prosecutor or defendant or anyone acting in the interest of either. Court is convinced the plea is accurate and has been freely, voluntarily, understandably, and knowingly made. Plea is accepted in order to enter upon the records of the court. Sentencing will be set for July 12th at 10:20 a.m. Defendant is referred to the Department of Corrections for the preparation of a pre-sentence investigation report. Bond is continued. Mr. McConnell, any questions or information for Mr. Middleton?
Thank you, Your Honor. Mr. Middleton, is your address still 8956 East Town Line Lake Road here in Harrison?
No, it's 8957.
8957, thank you. And what is your phone number?
I don't have one. I had a cell phone, but I broke it.
Okay. As soon as your hearing is done today, you need to report downstairs and see the clerical staff, and they will get you your PSI packet.
Okay, sir.
Thank you, Your Honor. That's all.
All right. Case is adjourned to the date time set for sentencing. You're all set, Mr. Middleton. Please go downstairs and meet with the staff down there.
Your Honor, I believe this concludes my cases before the court this morning.
I believe it does. Thank you.
Hey, Mr. Middleton, let's go.
Your Honor, I do have Mr. Matt on, he doesn't have his audio in me.
All right. We have Ms. Tomczyk still? Okay. Different desk. Calling the case of the people versus Brian Allen Knapp.
Good morning, Your Honor. Mark Webb on behalf of the people.
Your Honor, Karen Tomczyk, here on behalf of Mr. Knapp.
All right, Mr. Knapp apparently has tried to zoom in, but is unsuccessful and there's no audio. So what we're gonna do is adjourn this. We'll reset this for sometime in June. And you can get a hold of your client, Ms. Tomczyk, and make sure that he's personally appears here.
I'm here. I'm here.
Okay, you're Mr. Knapp?
Yes, I'm sorry. I'm having all sorts of technical difficulties right now with my stuff.
All right. And, Ms. Tomczyk, do you need to talk to him?
I do, Your Honor. My thought would be is at this point, based on my schedule, maybe we could adjourn it for a status conference in June. I just received kind of an updated offer from the prosecutor, so I could talk to my client about that. And we can discuss whether or not he wishes to accept that.
All right, we will set this for another status conference in June. And again, I'm going to request that Mr. Knapp personally appear in court.
Okay.
All right.
Okay, what day would that be?
We'll be sending notice to your attorney, so make sure you keep in contact with your attorney to know that, because if you fail to appear, a bench warrant will issue for your arrest. So
Yes, sir.
keep in contact with your attorney.
Yes, sir.
All right.
Again, I'm sorry about this. My phone was not cooperating.
All right, you're all set. You can sign off.
Thank you.
Thank you.
Can you identify for the court, please? Sir, can you identify, please?
Goodrich.
Sir, can you hear us, Mr. Goodrich?
Yes.
Okay.
Calling the case of People versus Timothy Joe Goodrich.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Goodrich.
And this is set as a status conference. Mr. Goodrich is currently in the Clear County Jail, is that correct? All right. You need to talk with your client today, Mr. White?
Yes, it probably would be a good idea, Your Honor. I have not had a chance to talk with him since I talked with his attorney in Wexford County.
All right.
Jerry, Judge, if I may. Jerry would be willing to offer a BK cap of 12 months. I think that's different from the original one.
Originally, it was a stipulated sentence, so.
Yep.
All right, Mr. White, we will put you in a breakout room with your client.
Thank you. I appreciate that, Your Honor. Thank you.
All right, we're in recess.
All right. Circuit Court now in session. The Honorable Roy J. Meeks presiding.
You may be seated. Recalling the case of People versus Timothy Joe Goodrich.
Good morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Goodrich.
You are Timothy Joe Goodrich?
Yes, Your Honor.
All right. And how are we going to proceed today, Mr. White?
Well, Your Honor, it's a little complicated. If the court will recall, Mr. Goodrich was the individual who we were working on, him going into Harbor Hall for treatment a couple of weeks ago, and that thing got adjourned because of an issue with Wexford County, because he's also charged with offenses in Wexford County. I've been in contact with his attorney there, Mr. Nathaniel Carnes, and he is moving for a bond modification so that Mr. Goodrich can go into the treatment facility or the treatment program. So we were willing to do that in the past. So I'm asking the court if we could set this matter over for a status conference out for a couple of weeks, because that Mr. Carnes indicated to me he is supposed to be in front of the circuit court next week sometime for the bond issue.
All right, you want to put on the June 14th motion day?
That would be, yes, Your Honor, for lack of a better time. And if there's any kind of a change, I might be able to contact your assistant to see if we can move that up.
Okay, we'll set a status conference for June 14th at 9:20 a.m.
Very well. Can I ask one more thing, Your Honor?
Sure.
Mr. Goodrich asked if the court would approve his retrieving his wallet from the evidence locker at the jail so that he can get into his personal belongings. And the jail indicates that the court would have to order that to allow that to happen.
Your
Any
Honor,
objection, Mr. Webb?
I'm not sure. I'm not sure if that's a piece of evidence or not. This wasn't originally my case. I'd have to look into it before I would say yes to anything.
Is there a specific document that he wants from his wallet?
Mr. Goodrich, specific documents?
No, I got cards and stuff in there I needed to release to my family.
What I would suggest is that you come up with a list, Mr. White, with your client, that you can put in an order, and if Mr. Webb will stipulate to it, the court will sign it.
All right, very well, Your Honor. Appreciate that.
Anything else?
That would be it, Your Honor. Thank you.
All right, you're all set, Mr. Goodrich.
Thank you.
Your Honor, would you like to do, Mr. Presley next, or?
Yes, I think so. Well, in the case of People versus Robert Joseph Presley Jr.,
So, Sean Brissett, appearing on behalf of people.
Your Honor, Gerald White representing Mr. Presley. Thank you.
you are Robert Joseph Presley Jr.?
That's correct.
All right. Any movement by either party in this case?
Not at this time, Your Honor, from the defense.
All right. Anything from the people?
So, Your Honor, I don't negotiate against myself, so if there's a resolution to the case from defense, I'd be happy to entertain it, but I haven't received any, so we're preparing for trial. The only thing I want to confirm with the court is if we are actually going to jury trial on July 20th, because we're sending out subpoenas, and I'm telling people in the middle of July that we are going and to not make vacation plans for the week that we are scheduled for trial. So I just want to make sure that we're set.
The way things are going, it looks like that's going to be the case.
Okay.
Unless something bad happens again, but everything's getting to be improvement. There's more vaccinations. They're loosening all the restrictions. So I'm expecting that in July, we should be able to have trials.
Okay.
That's fine with me, Your Honor.
All right. And in this matter, the plea offer was plead to count 1 as a habitual offender 3rd with a DK agreement for the A grid, cap at 135 months with credit for 32 months. Is that correct, Ms. Ambrositis?
I'm looking at I gotta look up the pleadings.
That's on the last pretrial statement that was submitted, and it's
That's what I'm looking at, Your Honor.
April 22nd. Huh?
That's what I'm looking at, Your Honor, the April 22nd pretrial summary.
All right. Okay.
Yes, so
Anything
that,
further?
no, I would just
Go
point
ahead.
out that the offer that was made would bring his remaining prison time to be served to 8.5 years.
All right. Okay. I know we have a July 20th trial date. We may set up a jury instruction date before that to go over the jury instructions. All right.
Okay.
That's fine, Your Honor. Thank you.
All right. You're all set, Mr. Presley.
unmute.
Mr. Rexford, you'll need to unmute your microphone, please.
I think we're good.
All right, calling the case of People versus Brian John Rexford.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Gerald White representing Mr. Rexford.
You are Brian John Rexford?
Yes, sir.
All right. And there's a final offer pretrial summary that's been submitted to the court. Mr. White, have you received that?
I just received it about an hour and a half ago, Your Honor.
All right.
I had an opportunity to go over initially with Mr. Rexford just this morning, but Mr. Rexford is wants to give some thought to it, so I'd ask this court to set this matter over, give him opportunity to think about what the new offer is.
All right, we'll set this for a status conference in June. We'll send you out a notice. The trial date is still set for July 21st.
And now, can I ask the court, is there a, Mr. Rexford indicates that there's a bench warrant out of Clare County for his arrest. Can the court give me because I don't have any record of that in my file.
Well, if he does, it's not in this case. I don't know if he's had other cases out there or anything.
Well, that gives me an opportunity to make some further inquiries. Thank you, Your Honor.
All right. Bench warrant for PPO.
Judge Evans.
Mr. White, he might have a bench warrant out for regarding a PPO of some type.
It's the same case.
Well, the PPO is a different case, and it's in front of a different judge.
Yes, sir.
Okay.
So you might want to look into that, Mr. White.
I will. Thank you, Your Honor. Appreciate that.
Yes, sir.
You're all set, Mr. Rexford. You can sign off.
Thank you, Your Honor. And you have a nice day.
Thank you, Your Honor. Does that complete my matters for this morning?
It does.
Okay, I'll see you this afternoon.
All right, we're in recess.
All right. The court's now in session. The Honorable Roy G. Nick presiding.
You may be seated. In the case of versus Dennis William Bonner, counsel identify for the record, please.
Chairman Zias, appearing on behalf of the people.
Good afternoon, Your Honor. This is Court Scott Holmes, the defense.
And you are Dennis William Bonner?
Yes, sir.
All right. Previously, you appeared in court and pled to the charge of assault with intent to do great bodily harm, less than murder, plus habitual criminal offender third. That makes that a felony with a maximum penalty of 20 years in prison. The minimum is discretionary with the court. Pre-sentence investigation report has been prepared. Sentencing guidelines are 38 to 114 months. Mr. Moore, have you had an opportunity to review that pre-sentence investigation report with your client?
Yes, Your Honor.
Anything of a factual nature that you wish to add to explain or controversy?
We do have an objection to the computation of jail credit, but aside from that, it is factually accurate.
Okay, all right. Any objection to the scoring of the guidelines?
Okay.
Ms. Ambrositis, on behalf of the people, anything regarding the factual nature of the report or the scoring of the guidelines?
Your Honor, we have had the opportunity to review the pre-sentence investigation report. We do find it to be factually accurate. We reviewed the prior record variable scoring and the offense variable scoring and find that to be accurate as well.
As to the credit issue?
Thank you. MDOC is indicating that my client should receive 1 day credit for his arraignment. The dates being 6/8/2020 through 6/9/2020. Sentence details pending arraignment sent to prison on Lake County case. This is on the CFJ 145, page 2, below Department of Corrections recommendation. The client was.
When was he sent to prison in Lake County?
He was already in prison.
When he was charged with this?
That's correct. Okay. The complaint was authorized by the prosecutor on December 2nd, 2019. He was in state custody from that point forward. So we contend that the state had actual notice of the arrest warrant on at least December 5th, 2019. That would have been when it hit lien. No arraignment was scheduled until July 9th, 2020, despite the fact that both the state prosecutor as well as the assistant U.S. attorney were aware of these pending charges. And he was not made available for arraignment until June 9th. So I believe that the prosecutor and I, if I may speak for her after our discussions downstairs, and I do appreciate the court's indulgence because this is at the first moment to resolve this issue. I believe that the people would agree to credit 351 days, but we maintain that credit should date back to December 5th, 2019, yielding credit of 537 days. I am saying this for the record. Mr. Bonner and I had discussed his attempts to be arraigned on this. He believes that he had sent a request for a writ of habeas corpus to the district court here sometime between November 1st and December 5th of 2019. Even if that is the case, the fact that the complaint was not authorized by the prosecutor until December 2nd means that the district court could have done nothing with that information. In any event, we believe that 571 days that we are proposing comports with the facts of this case, but I appreciate the offer of the prosecutor to stipulate to a lower amount. Thank you.
The problem I have is there's a statute that says if they're currently under serving a sentence of some other type in prison or in jail, they're not entitled to any credit. So
that,
but,
Your Honor,
but Ms. Ambersitis, you're willing to stipulate to 351 as credit?
We would stipulate to that, Your Honor.
All right. So then we'll put down that it was stipulated credit for 351.
Thank you.
All right. Mr. Barnard, is there anything you wish to say to the court before the court passes sentence?
The only thing that I didn't hear is we were going to put on the record that this is going to run concurrent with my state and other federal sentence, Your Honor. Am I correct about that, Scott?
That's part of the agreement.
Okay. And the other one, can we go over the agreement one more time, Your Honor?
If I may, Your Honor, since we're not in the same location. Mr. Bonner, I had not forgotten your request as regards the sentence agreement and the concurrency. I was reserving that for elocution. Right now, we're discussing factual challenges to the pre-sentence investigation.
We're at the point where he gets to elocute. And that's why I'm asking if there anything he wishes to say.
He's made a request that he have the offer read back to him. If you were standing here, I would just show it to him. But if I may be allowed.
You may be allowed.
Thank you. What we agreed to, Mr. Bonner, was you would enter a plea of guilty to count 3, assault with intent to do great bodily harm as an habitual offender, third offense notice. Sentence recommendation, Briggs Killebrew cap, not a stipulated sentence, but a cap of 4 years initial incarceration with your current sentences in the state and federal system. Restitution to be determined to the victim, Corey Pumphrey, Other terms, conditions, pay restitution of $2,753 in file 21-6534 FH with dismissal of that case entirely upon sentence and appeals period running in the above referenced case. This is from the pretrial summary that you and I discussed and I signed on your behalf on February 18th, 2021.
Yes, sir. That definitely answers that question. My last question for the court before we proceed is the restitution of to be determined.
It was actually stated, it was, Mr. Barnard, it was stated, if you would have listened to Mr. Moore, he stated it was in the plea agreement at $2,753.
Okay, I'm sorry, Your Honor, I'm hard of hearing and this speaker is not very well here. All right, I guess I'm good, Your Honor. We can proceed.
All right, anything else you wish to say?
Thank you for the leniency of the court and the prosecutor. I appreciate everything that everybody's put together for this plea for me.
Mr. Moore, on behalf of your client.
Thank you, Your Honor. This is a Briggs Killebrew negotiated sentence with a cap of 4 years initial incarceration to run concurrently with his current sentences in the state and federal system. Overall, the recommendations made by the Department of Corrections seem appropriate, although I do believe that the probation terms are surplusage, and I would ask that those not be formally ordered by the court at this time. I'm asking the court to exercise its firm discretion in staying within the Briggs Killebrew cap. Thank you.
Ms. Ambrositis, on behalf of the people.
Thank you, Your Honor. We're going to ask that you follow the recommendation in the plea agreement in this matter. Furthermore, I would note that the restitution in the other file of $2,753 be assessed. It is not included in the pre-sentence investigation report. And then I would note for the court, and I have advised Mr. Moore of this, that one of the other victims in the companion case has advised us as of yesterday, late afternoon, that insurance did not cover some of the stolen property, and there could be an additional request of $6,100 for restitution. We have not received that information yet, but once we do receive it, we can certainly file a post-judgment motion for restitution. Thank you.
Are there any victims present that wish to speak to the issue of sentencing?
I'm here.
All right, state your name.
My name's Amanda Frosch.
All right. Is you a victim in this matter?
Well, I just had my Jeep stolen, but to me, that's a pretty big deal. So I just like to tell this gentleman exactly what he took from me.
Go ahead.
So I'm sorry, what's your name? Mr. Bonard?
Bonard.
Can you hear me?
Ma'am.
Yes.
Yes, I can hear you, ma'am.
I've already listened to you, and it's apparent to me how selfish you are. But I'm going to tell you exactly what you took from me, okay? It was a 1986 CJ7 Jeep sitting on 31s. So I'm going to tell you a little story about it. I was like 8 when my father brought that Jeep home. We went up north. We went everywhere with that. We had our cabin. I went to Leota with it. We hit the first deer we ever hit in a car. Still have a dent in my forehead from it. Got it stuck in a mud hole. That was my connection to my family and all the people I've lost in my life. Everybody that's dead now. That Jeep got brought home for me to drive when I was 16. I took it to high school every single day, and everybody named it Spartacus. I'm now almost 40 years old, and if I run into someone in high school, you know what they ask me? Hey, you still got that Jeep? Hey, how's Spartacus doing? So a couple years ago, my mom got cancer and she died. So I was stuck taking care of my dad. I couldn't get up to my cabin. What happened? Some idiots broke in and went through all of my stuff, busted it all. So while I'm in a hospital, I go up there to see what they took and see that they went through all of my stuff. And the only solace I had was that they didn't touch my Jeep, right? So I decided, hey, I gotta let this go. I gotta let this cabin go. So as I watched my dad with Parkinson's and Lewy body dementia, fully bedridden, I spent 6 years of my life taking care of him every single day. Every day I saw the worst of it. And the consolation to me was, you know what? I have to sell that cabin, but I'm going to bring that Jeep home. Because that was my dad's Jeep. That was my Jeep. That was so many memories to me. Just a Jeep to you, right? Just a Jeep. No big deal. This is what I got now. I got a photo of it. Why? I don't know. Why you felt you needed to come take something from me. You have no idea what you took. No idea. It's just a car to you. That's all the memories I have. My parents are gone. I was going to bring that home and restore it and have that be the connection to everything that was that is no more. And instead, before Christmas, I get a phone call from the sheriff up there again to tell me some idiot broke into my garage and stole my stuff. You can ask him. I had to set down the phone and scream because I was so angry. Then I drive up there. So I leave my bedridden in-hospice father to come deal with what you did. I get up there to the tow shop and see that you took my freaking Jeep and ripped everything off of it. They had a custom paint job, pinstriping. Mitch still on the hood. That's how I knew it was mine after you rattle canned it and left it in a ditch. You didn't care about my stuff. It's not about stuff. You have no idea what you took from me and what it meant to me. And sitting here looking at you, I can see that you don't care. So I hope whatever
That's
else
not true
you
at
did,
all, man.
listen, no,
That's not true at all.
It's my
Okay,
turn.
Commander, this is your time to listen. It's her time to talk. You can continue.
I don't even want to see the look on your face. I don't care what else you did. I hope they put you behind bars until everything that you have is taken from you so you can feel like I do. You could have got a job, been a productive member of society and given back because that's what we're supposed to do as human beings. That's what I do every day of my life. But instead, I'm constantly called away to deal with people like you, and I'm tired of it. You are what's wrong with people, and I hope you pay for everything you've ever done to anyone. That's it.
All right, thank you. Are there any other victims present that wish to speak?
Yes, Your Honor.
Okay, go ahead.
My name is
What's your
Todd
name
Van
first?
Harder,
All right.
and I'm part of the restitution that the prosecuting attorney spoke about. Basically, the items that were stolen from my property, a trailer, an ATV, a Generac generator with less than an hour on it, plus some other items, basically were never covered, compensated by my insurance company. They were 100% financial loss to my wife and I, which my wife is on disability. As a part of that consideration, that ATV was her way to get around the property, to use it with her grandchildren, basically to enjoy that property. So it has taken us 2 years basically to replace the ATV and the trailer based on our limited income. The other items, basically as we can, we'll see to replace them. But again, they were never found, never located. I can only assume they've been sold somewhere. And there was no financial restitution by any insurance company. Thank you.
Thank you. Anybody else? Let the record reflect there are no other victims present who wish to speak. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 38 to 114 months. This is an agreement for a minimum sentence being at 4 years. Although the parties stipulate to 351 days credit. Court, after hearing the victims in this matter, probably unlikely to ever see restitution in this matter, even though it will get ordered. It's not going to go along with that stipulation for credit. The court doesn't have to. It wasn't an agreement at the beginning of the plea, so he's not allowed to withdraw his plea.
Your Honor, just for the record, the defense relies on MCL 769.11B for credit time served prior to sentence. I'm not going to argue any further on it, but I believe that is the appropriate statute, the one I relied on when I spoke to the prosecutor. Thank you.
Well, if you want, we can delay this and we can review the statutes and find the statute that says that he's not entitled to any kind of credit if he's already serving a sentence. You wish to delay this and reset this for another date so that we can review those statutes?
I would like to bring something to the court's attention. I'm not sure if this matters or changes anything, but when I was arraigned, I was in the U.S. Marshal's custody in Newaygo County Jail, waiting, or I had already been sentenced in the federal system, but I have got no time credit for my federal sentence. I had yet to be sentenced on the sentence that I'm serving right now, that I'm here right now in MDOC for. So I technically wasn't serving a sentence yet. I was still, you see what I'm saying? I was in the custody of the U.S. Marshals at the time.
I'm going to say this, it's going to take a little bit of research, review of the statutes and review of what you're actually in for. I don't know. Were you on parole at the time? Were you in the, I guess it's
I was not on parole, Your Honor. I was not on parole.
If you want that issue reviewed, then we can adjourn this sentence for a month and I'll have the prosecutor and the defense attorney review those issues.
Yes, Your Honor, we appreciate the opportunity. Thank you.
All right.
Scott, is that your recommendation?
We're going to adjourn this sentencing for about a month. We'll set a new date and the court will expect a memo from the prosecutor and the defense regarding the issue of credit.
Yes, Your Honor. Thank you.
All right. We're in recess.
All right.
All rise, 55th Circuit Court is now in session. The Honorable Roy G. Mink presiding.
You may be seated. Calling the case of Lindsay Makita and Brooke Makita versus Tom Berger and Kelly Harrison. Counsel identify for the record, please.
JJ Klaus, Your Honor, representing the plaintiffs' counter defendants.
And good afternoon, Your Honor. I'm Jay Brown, representing the defendants and counter plaintiffs.
All right. We got two competing motions for summary disposition. Defendants filed theirs first. Who filed first?
Boy, that's a good question, Judge.
I think we filed about the same time.
All right. You want to just combine them and do them both together?
I think that's probably the best efficient use of time.
All
I would
right.
agree.
So I guess we'll let plaintiff start first.
Okay, thank you, Your Honor. Your Honor, a couple just Housekeeping facts here. I just received defendant's response to my initial motion last week. In that motion, there were a few more affidavits that I was not familiar with. I know that they were signed on the 11th, but I did not receive them until late last week. And I understand based on those motions that the trespass nuisance claim and some of the other items are not necessarily ripe at this moment, are open to some factual disputes, which I think depositions and things will probably be necessary. And, you know, in fairness to Mr. Brown was late on this case. There were other attorneys involved. I have not received the disclosures, and Mr. Brown, I don't even think I brought that up to you, but I haven't received disclosures yet. So I think based on those new affidavits and some disclosures, those issues might have to take a step back here. However, I do think the issue on the fee simple easement and use of the easement is ripe for today. There are a few things that we do agree on, I think, and one of those would be that there is a recorded survey containing this easement and 4 parcels of land. That this easement is for ingress and egress purposes, utility installation, and it was deeded with all of the lots that are back in that area. I don't think there's any dispute to that. I think the dispute comes into place in whether or not there's a fee simple interest that was deeded with those documents and whether or not the plaintiffs may use the entire easement as was conveyed to them. The defendants would like this court to make a declaration that the plaintiffs do not have a right to use the easement other than to access their property off of Lakeshore Drive. And they ask that the court, they base this on the fact that they're saying that Regent Franks, who was the original developer here, actually conveyed this easement with the first parcel that went out, which was parcel K. I think in my, I have a title opinion that was attached to my corrective brief there. That does a very good explanation of the title work, the land records, tax records, and those kind of items, and also the Michigan land title standards that seem to agree that the fee simple interest is with the plaintiffs at this point. However, I understand that's disputed by the defendants. I'm going to try to make this brief. The defendants argue that parcel K was deeded out by Regent Franks back in 2002. And at that time, it was recorded in July 3rd of 2002. In that, they claim that the easement was deeded with that parcel. However, if you look at the deed itself, which is Exhibit J to my initial motion, the deed itself on its face indicates that it's only parcel K that's being conveyed. There is an attachment to the back of it that includes a description of the easement that is contained exactly in the survey. And this is the same easement that was conveyed with every other parcel in that area. One of the arguments they make that Regent Franks intended to convey this is that they did not keep it and pay taxes on it themselves. Well, nobody paid taxes on this parcel. It was never assessed to anyone. And second of all, the tax records do not make any, the tax records have no weight in conveyance of documents. In other words, in order to look at this argument, we have to ignore the fact of what's contained in the registered deeds office. And I think there's plenty to dispute the fact. If you look at the recorded documents and the Michigan land title standards, it fully supports plaintiff's position as to how the conveyance came out as to the fee simple interest in the easement itself. I'm a little bit concerned with the fact that the defendants would like to somehow reform this survey. In other words, they're claiming that the plaintiffs no longer have a right to use what was deeded to them past their property, which doesn't really make sense since we have a survey. The court would have to reform the survey itself, also reform all the deeds that came out of that conveyance, and then I think it leaves a lot of questions up in the air about other condominium associations. Does every condominium association that has a roadway that's deeded in it only have a right to use it up to your house? Or is that common property that was intended to be deeded, in this case, as a roadway? From our perspective, Your Honor, we have a chain of title, a full chain of title that complies with the Michigan title standards. It's recorded in the Register of Deeds. And we asked the court look at that and those items that are in my brief to determine that the fee simple interest at this time, as is consistent with the title opinion, is with the plaintiff. I'll let Mr. Brown address any of those concerns.
All right.
Okay.
Mr. Brown?
Excuse me. Thank you, Your Honor. And I agree with Mr. Klaus that some of the peripheral issues are not ripe for determination today, because the trespass nuisance, that there are questions of fact, and that rightly all motions should be denied in terms of that, meaning the plaintiff's motion. And I also agree with Mr. Klaus that the real issue before the court is the determination of the fee ownership and the use of this easement area. Now, we can't dispute the deeds that were recorded. They're obviously there, or the order of recording. The question before the court is going to be, what do the deeds mean? And who has rights based upon what deeds were out there? Now, we know a couple things. We know that parcel K was the first parcel sold. And what we know with parcel K is the description itself includes, as part of parcel K, it says see easement description sheet 3 of 3. That's the only parcel in the description that references particularly the easement itself. So I think it's clear that with the deeding out of parcel K, with the note thereon on the bottom of the description, see easement description sheet 3 of 3 is what it says, that the easement went with parcel K. I don't know how else you can define that description, because it doesn't say as part of parcel K an easement. It says see easement description, which then brings it, the easement itself, the fee title to the easement itself, comes back into as part of parcel K. The other side says, well, Judge, you shouldn't look at it that way. You should look at it as just parcel K plus the easement. Well, we disagree with that. And then you say, well, how did the parties act thereafter? Did they act consistent with the description as we say, or did they act consistent with what Mr. Klaus says? And what we know is, and we've presented affidavits, that first of all, Regan Franks never paid taxes on an easement area as a separate parcel. So we know it wasn't something that Regan Franks intended to retain. Otherwise, it would have gotten a separate tax parcel. It would have been taxed separately, and they would have maintained ownership. They didn't do that. So Regan Franks had to have been of the opinion that the property underneath the easement, the fee interest, had to have gone to one of these lots. So the question is, which one? And again, we point to parcel K by its express description in the bottom of parcel K, incorporating the easement. So it incorporates the easement into parcel K. The second thing we know is we know that the parcel K has been taxed as the owner of the easement and has been considered the owner of the easement by the township and by Clare County. And we submitted with our motion an affidavit from the supervisor Scarborough, based upon records that indicates that it's always been, to his knowledge, always has been taxed as part of parcel K. So if it wasn't part of parcel K, then you would think an owner of parcel J or parcel I or Regan Franks itself would have objected. But it's a public record, and it's been a public record for years, going on 20 years now, that the easement itself, the fee interest, belongs to parcel K. And so it makes you, again, it's evidence of what was intended by the grantors. And certainly, if I thought parcel K didn't own the easement and I owned I or J, I would have looked at that tax description and said, well, wait a minute, that's not owned by you. But nobody did that over the last 20 years. It was only until this most recent dispute that the ownership, the county and township determination or consideration of parcel K as the owner of the fee interest was ever even questioned. It took a dispute to bring this up. And now people are saying, well, wait a minute, those tax records must be wrong. The way the county GAS had it must be wrong. We submit that's not simply the case. We submit that from the deed, from the initial deeds, and the fact that parcel K is the only description that includes within it an incorporation of the easement, that easement fee interest belongs to parcel K and has belonged to parcel K since it was initially deeded out, and that we ask that this court hold that parcel K is the owner of the fee interest in the easement, owns the land underneath it. The second thing that we would like this court to
I have a question for you, Mr. Brown, because the deed to parcel I also had that same description attached, and it says see attached.
Correct.
So then it had the easement included in that too?
Well,
and so does that, so then we come down to the title standards, who recorded first? So is your claim that any deed that was recorded with that parcel and the easement attached, that was a transfer of that easement property?
Yes,
because if you claim that, then clearly the deed for parcel I was recorded first. This is a recording first state.
Yeah, no, that's not what I'm claiming, Your Honor. What I'm claiming is there's a difference in the description of parcel K. The last line of the description of parcel K references, it says see easement description, sheet 303.
Okay.
It's our position that brings the easement.
Doesn't that mean that that's an easement? See the easement and the description of the easement? Can't that be inferred that way or interpreted that way?
Yeah,
that's what I think I would interpret it as see an easement description. There's an easement.
Yeah, I think the way that the parties and exclusively the governmental institutions interpreted that is as we submit, which is parcel K owns the property under the easement. Now I know that parcel I indicates that there is an easement, but it does not include the same language incorporating the fee ownership of the easement into parcel I. Simply says that there's an easement. So that's the distinction. And the distinction, while it's in the deeds and it's in the description, is what it is. We know that the township and the county continued that through for the next 20 years. And looked at that and assessed and determined that parcel K also owned the fee to the easement. So that is what we request that this court would find in terms of the ownership of the fee. The second part issued today is that there is an easement. Our parcel I does have an easement. We believe ultimately that it should be limited to the direct access that they have directly in from Lakeshore Boulevard. That a second driveway is an impermissible expansion of that easement. I think that question may have a question of fact. But the other part of our motion and what we request that the court find is that the easement itself for parcel I, since it is only for ingress and egress, that it end at the border with parcel J, because there's no need to go past the border between I and J to access parcel I. So we think that the line is drawn at the boundary between I and J, and any easement, and we don't know exactly, because I think it's a question of fact as to what types of access they can have off of the easement to parcel I, but any easement or any use by parcel I of the easement would end at the boundary between I and J.
Anything else?
No, sir.
Yes, Your Honor, may I respond?
I was just asking Mr. Brown anything else. I'll go back to you and then I'll give him some more rebuttal time too.
No,
Thank
sir.
you.
All right, Mr. Klaus?
Yes, I'd just like to point out that Mr. Brown is mistaking into the assessment of parcel K. At no time, and we've actively and diligently had the title company search the tax records in every aspect in every way. And parcel K was never taxed for the easement. It has never been assessed to any of these parcels. It was a separate property that was intended to be a roadway. So it wasn't taxed. Nobody's paid tax on it. That's number one. Number two, the GIS and tax records are not instruments of conveyance. The GIS and the tax records also indicate a disclaimer saying that you can't rely on these for chain of title type of information. Michigan Land Title Standards 3.18 gives us that the first to record is the first in time if they take it without knowledge. In this case, there's no question that the chain of title to parcel I was recorded prior to parcel K. If defendant is arguing that the first deed out was the case, then that language would apply to the same thing in parcel I, and therefore parcel I would be the owner of it. The distinction that Mr. Brown makes as to the the attached is actually the second page of the survey itself. And that's only referencing all three parcels. I've spoken to the surveyors. In full disclosure, I'm the one who drafted the condominium documents for Norwegian Woods. And that reference, distinction that Mr. Brown is relying on is a reference that this easement applies to all the parcels, and it is separately described. And in the descriptions, it states an easement described as. And in this case, they were granted the full easement, a meets and bounds survey. I think it's to take away a property right based on what a presumed supervisor assumes to be the case and what people might have believed is not how we dictate land records in Michigan. And I asked the court to follow the Michigan Land Title Standards. We have received a deed from the company, Region Franks, directly to the plaintiffs in this case, pursuant to, I believe it's 10.3 Land Title Standards. And if you read that title opinion that is attached to the second part of my brief there where I corrected that one date, that does a very good job of explaining all the details in this case. Thank you.
Mr. Brown, rebuttal?
Yes, a couple things. First of all, what Mr. Klaus says that a surveyor may or may not say is something that this court cannot consider. That's hearsay. That's not anything that's before the court. Also, that land title letter, it's an unsigned letter from a professional, was not submitted according to the along with the motion, so it's not properly before the court either. An unsigned supposed opinion submitted well after the deadline to do so. So that cannot be considered. Based upon what the court has before it, though, the parcel K, the express reference to the easement within the body of the language of parcel K, combined with the treatment by the local officials and taxing parcel K as part of the easement as part of parcel K. And when Mr. Klaus says that that's not the case, I point to the Reading Township Supervisor's affidavit indicating it was always considered as being owned by parcel K and taxed as parcel K. So I don't know where this other evidence that Mr. Klaus is speaking of, but we ask that the court hold that parcel K as the owner of the fee simple of the easement, and that the easement end at the location at the border between I and J, and then the other remaining issues, as Mr. Klaus noted, are something that will have to be before the court subsequently.
Anything else from either party?
Your Honor, I'm not sure what a township supervisor has to do with the assessor. Defendant has acquired no information from any assessor, just what a town supervisor believes, who happens to be married to the same person that notarized and is a witness in this case, who notarized Mr. Berger and Mrs. Harrison's statements at the same time, had a different notary testify to the affidavits that she herself had signed. These things are going to have to be flushed out. I guess the veracity of those affidavits will have to be flushed out in the deposition. But the tax records, and I believe my brief speaks to it, whether you want to consider the opinion or not. She is named as a witness and will be there before the court. But my briefs and statements in my pleadings clearly indicate that the chain of title belongs to the plaintiffs at this time. Thank you.
Any last words, Mr. Brown?
No, sir.
All right. They say the fee ownership is a legal question in this matter. This is a recording state. The court does not buy the argument of defendants that that little asterisk means that that easement was to be included in parcel K. That's not really how it reads. I don't think that's a proper interpretation of it, but still, nonetheless, this is a recording state. And the plaintiffs have a deed from the company for the easement property. And the court just looks at it. Sometimes the company that did all that just forgot about who they're going to deed the easement to. You don't have any affidavit from them saying that they meant, and they wouldn't have signed a deed if they meant to transfer title to that easement to your clients or your clients' predecessors. But they signed a deed transferring the easement to the plaintiffs. So the court's ruling is the fee owner of the easement are the plaintiffs. Now, part of the plaintiff's complaint was also regarding a trespass regarding the parking of the trailer. I think the facts are all there. It's undisputed. Apparently, Mr. Berger thought that he owned the easement so he could actually park that trailer there and block anybody's use. Unfortunately, he doesn't. So I think the facts are all in on that he's guilty of trespass by doing that and blocking that access. So the court rules summary disposition for the plaintiffs on that issue. The issues of nuisance and trespass for the increased water, there's genuine issue of fact between the parties on that. So the court's not going to grant any summary disposition to those issues. And as a side note, whatever the tax assessors do, the township supervisors, that what they believe who owns a piece of parcel is not necessarily valid. I've seen a case in front of me that a tax assessor found out that the road cut through a property and what he thought was all on one side of the road. What he did is he drafted new tax parcels for the property that occurred on the other side of the road, sent out tax bills. Nobody ever paid them because they thought they were just paying on their houses. I don't think he had any legal authority to do that. Not at all. Not without maybe some description and telling the parcel owners, we're dividing your property and giving it a new tax number. But that's the kind of thing tax assessors do. They're not lawyers. They don't know how to transfer property. And so anything that your supervisor, tax assessor say doesn't really carry anything. Now, I know in a lot of cases of adverse possession, people claim that they paid the taxes and that's part of the reason that they claim it. But I've never seen a case or a court case that said, oh, they paid the taxes on it, so therefore they win. So it's pretty clear the fee owner now is the plaintiff. And before, it was Reagan Franks who failed to dispose of all their property. So court's going to quiet title to the plaintiffs on the easement description as their property. And any other issues that aren't settled with that remain on the trial docket. Any questions, Mr. Klaus?
No, Your Honor. Thank you.
Any questions, Mr. Brown?
No, sir.
All right, we're in recess.
All right.
The circuit court is now in session with the Honorable Roy G. Mink presiding.
You may be seated. In the case of People versus Jeremy Philip Barker. Counsel identify for the record.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Joel Kershaw on behalf of Mr. Barker.
All right. We have a motion. Defendant's motion to withdraw plea and or correct the invalid sentence. You may proceed.
Thank you, Your Honor. And I trust that the court has, I'm sorry?
For the record, do we have Mr. Barker present or via Zoom? All right,
Yes.
okay, you may proceed.
Okay. And Your Honor, I trust that the court has read my pleading in this and understands the basic gist of the argument.
I did, and at the end of it, you requested that a chance to file an amendment after you had the ability to talk to Mr. Barker. Were you going to file any kind of amendment?
And it's not my intention. I spoke to Mr. Barker, went over the motion that I filed. I believe that the motion that I filed covered all of his concerns, so I'm not intending to file an amendment to the motion unless the court expressly asked me to. I think that the issues I raised in that motion are the issues that Mr. Barker would like to have raised on his behalf. I do appreciate the courts granting us that flexibility due to the difficulty that we had scheduling meetings earlier this year with the COVID pandemic. But essentially, I guess the concern that I have when I was reviewing this case, that the thing that stuck out to me is that Mr. Barker entered a no contest plea, and a no contest plea, just to put it colloquially, typically is not him saying he did anything. It's not him saying he didn't do anything. It's just simply saying that he's choosing not to fight this case. And typically in a no contest plea, the court requires that some other factual basis be provided other than an admission from Mr. Barker, because that goes to the very nature of a no contest plea. In this particular case, the factual basis for the no contest plea was based upon a statement that was prepared by the prosecutor, signed by defense counsel, and what concerns me somewhat is that it was signed by Mr. Barker as well, which after he specifically said that he wasn't able to admit to specific facts as to the allegations against him, he was still.
I don't take that as a omission of the facts included in the offer of proof. I take that as he's recognizing that's what the offer of proof is. So
okay.
So
and I appreciate that clarification.
Any from the prosecutor that he's admitting to those facts, that's not true.
Okay, and I appreciate the clarification of that on the record, because that was the first time I had ever seen that particular format used. Not saying it's right or it's wrong, just simply saying that's the first time I'd seen that. However, the reason that creates problems and goes into my motion is because the statements contained in that offer of proof were then used to provide a factual basis for some of the sentencing variables, specifically in regards to, I believe, OV4 and OV11, if I'm remembering correctly. And that would be in my motion. However, there was no evidence. There's no evidence at the preliminary examination. There was no evidence produced anywhere in court in the record that would support the court's findings for the scoring of those offense variables. And so, because of that, I don't think that the court can rely solely on a blanket statement and offer of proof that says, for example, in regards to OV4, that Mr. Barker, or that the complainant in this case, sustained some sort of psychological injury when there was no evidence presented to that, merely an offer of proof, which is in and of itself not evidence. So the court can't find by a preponderance of the evidence that there was psychological injury to the complainant in this case, where all we have is to go on as an offer of proof. Same thing with the number of penetrations. We have an offer of proof where, I believe, if I remember correctly, Mr. Barker, the statement said that there was at least 2 and as many as, I believe, 5 or 6 times when there was a penetration that occurred. But once again, first of all, that's not evidence. And second of all, even taking that evidence, there's not anything to establish the 3 or more penetrations that the offense variable requires in order to support that scoring. So for those reasons, I believe that the offer of proof is insufficient to provide the evidence necessary to support a scoring of the offense variables, and I believe that those offense variables need to be rescored. The other issues that I raised in the motion deal with, first of all, the representation made by the prosecutor's office at the time of the plea, indicating what his sentencing guideline range would be, and that Mr. Barker entered into the plea believing that that's what the range was going to be, and that the sentencing agreement was to the middle of that range. And it turned out that as we got to sentencing, the sentencing guideline range was quite a bit higher. I would argue incorrectly so because of the issues that I raised. But if the court were to find that the challenge guidelines were properly scored, then we've got an issue where Mr. Barker entered into a plea based on a representation that the guidelines were going to be one thing and that he was going to be sentenced to the middle of those guidelines. Turns out that the guidelines are something completely different, and he's sentenced to the middle of that guideline range, and so he didn't get the benefit of what he bargained for. Now, I understand that the statement of the guidelines on the record was a preliminary estimation of the guidelines. I think, and I would say that my argument would be different if it had been the defense attorney had said, I believe the guidelines are such and such, because though that would be, arguably a calculation of the guidelines that was done in the light most favorable to Mr. Barker. But this was the prosecuting attorney saying, we believe the guidelines are such and such, and presumably the prosecuting attorney would have calculated the guidelines in the light least favorable to Mr. Barker. So I think that lends to the position that the plea was not understandingly made, because he believed that the guidelines were in one range, and they turned out, if the court disagrees with our argument as to the challenges to the specific offense variables, and the guidelines would be different than what Mr. Barker was advised they were at the time he entered his plea. And then finally, this case presents a third conundrum for me as an attorney, as a defense attorney looking at this, and that Mr. Barker, I've spoken to Mr. Barker now on several occasions. I've read through the record, and from what I can tell, Mr. Barker has been steadfast in maintaining his innocence to these charges. I don't see that it's ever appropriate to have a defendant who maintains his innocence. It's not he's saying that he doesn't know if he did it. He's not saying that I don't remember doing it, but I might have done it. He's saying I didn't do this. And under those circumstances, it's wholly inappropriate for him to have entered a no contest plea in this matter. And it was inappropriate for trial counsel to allow him to do so. And I think it also goes to the accuracy of his plea, because a guilty or no contest plea has to be understanding, voluntary, and accurate. And this is frankly not an accurate plea. And I would state that the very fact of taking somebody who steadfastly maintains his innocence into a no contest plea, and for the sake of resolving the case, that in and of itself reeks of ineffective assistance of counsel at the very least. And even if it doesn't, I think the mere fact that the plea is not accurate, that Mr. Barker does maintain his innocence, does not acknowledge responsibility, doesn't claim that he doesn't remember, doesn't claim that he, that he's only doing the no contest plea for civil liability. He was encouraged to take the no contest plea because he doesn't believe he's guilty, and his attorney wanted to get a resolution short of trial. And frankly, when a defendant maintains their innocence, the appropriate remedy is to go to trial, not to enter a plea. And for that reason, I think a plea withdrawal is necessary. For the issues concerning the scoring of the guidelines and the lack of evidence in support of the guidelines that we challenged, I would say that if the court's not inclined to allow Mr. Barker to withdraw his plea, the court at the very least should grant him a resentencing, at which time he would be sentenced according to the guideline range as it would be accurately scored if those offense variables are changed.
Mr. Webb, on behalf of the people.
Good afternoon, Your Honor. I think we need to correct the assumption that the defense is making regarding what was used as a factual basis for the plea taking in this case. It's my understanding from a review of the case and looking at the transcripts that it was a preliminary exam transcript that was used for the factual basis. And the offer of proof was presented at some point after that. And given that, there was testimony from the victim, I believe, at the preliminary exam, and that would go to the scoring of the guidelines. I believe OV4 was scored correctly. That was the, I think, psychological injury. Taking into account the victim's testimony, and then the, I think the allocution by our chief assistant on behalf of the victim at the sentencing, she stated that the victim had been in therapy as a result of these crimes. And that right there would provide a basis for scoring 10 points for OV4. OV13, again, the number of penetrations. It's my understanding the victim testified to this at the preliminary exam. And I forget exactly what it added up to, but I believe it was much more than 3 penetrations. I believe it was up to 6 or 7 that she described during her testimony. So I think those are scored correctly, and I don't think there's any reason to correct an invalid sentence in this case. And I also, the court can correct me if I'm wrong, but I don't recall if the defense attorney objected to the scoring of guidelines at the sentencing. Judge, I believe that the rules of the case law indicate that one of the one of the things a defendant has to show or prove for a motion to withdraw a plea is that the plea taking itself was not correct. And again, I would ask the court, and I'm sure you probably already have reviewed the plea taking transcript itself. And I'm sure this court has clearly go over all of the defendant's rights and make sure he understood what those rights were, and that if his plea was voluntary and accurate. And I would also remind everyone that the defendant was put under oath before his plea was taken. And I think it's clear from that transcript that he understood what he was doing. He did it voluntarily, and that the plea was accurate. I think that any claim that he relied on his plea or his sentence because of what the prosecutor suggested, what they scored the guidelines to be, is not a genuine argument, Your Honor. I think the transcript shows that the chief assistant again reminded the defense attorney and his client that that was an estimate that the prosecutor had scored of what the guidelines were. And then I'm sure in my review of the transcript, again, Your Honor informed the defendant probably near the end of his plea taking that or the court has not entered into any agreement or made any promises as to what his sentence would be. So he knew that he should have understood at that point that shouldn't be something he could bring up later. As far as the ineffective assistance of counsel, again, I don't think that's an argument that has any merit. There's a two-pronged standard for ineffective assistance of counsel involving plea taking, and that is whether the representation was below an objective standard of reasonableness, but for the deficient performance of the defense counsel, there would have been a different outcome. It's my understanding that part of this plea agreement was that there were other CSC first charges that were dismissed as part of the plea agreement. So there was some benefit to him, to the defendant, for taking a plea and not going to trial.
Used against me on the scoring.
I don't believe I have any other response at this time. Okay. All right.
Rebuttal?
Yes, Your Honor. First of all, as the prosecutor was speaking, I did pull up the preliminary examination transcript, and the first argument that was made was that the preliminary examination transcript, not the offer of proof, was the evidence that was used to support this court. I'll pull up in reviewing the preliminary examination transcript, looking directly at the scoring of OB13, I'm looking specifically at the language of the district court that says the court's only permitted to consider that, and this is on page 20 and 21 of the preliminary exam transcript, says the court's only permitted to consider the testimony and evidence present in this case. The only evidence presented today is statements of the complainant, and I'm not going to say the complainant's name, and she testified today that on 2 occasions the defendant did place his inside of her vagina. The first being jurisdiction having been established in Clare County, and that it did occur as referenced on the time of the couch. The second in her mom's bed. So I'm looking at the evidence there. The direct finding of the court is that there were, of the district court at that time, the court that actually had heard that evidence had stated that there were 2 penetrations that occurred. And I apologize, I'm just trying to pull up that there were 2 penetrations that occurred. There was no finding that there were 3 penetrations that occurred. The only place in the record where there's any even plausible argument to be made that there were 3 penetrations that occurred would be in that offer of proof, which we've already established. I think that if I'm understanding the prosecutor's position correctly, it's already conceded that's not evidence. That's not the evidence we're relying on for the purpose of the and therefore that does not go into the scoring movies. We look to the preliminary examination transcript for the evidence as to that. And the preliminary examination transcript, the district court judge acknowledged that there were 2 penetrations, not 3, not 4, not 7, not any other number. Therefore, the scoring of 50 points to OV13 is erroneous even by the findings of the district court judge who had bound that matter over. My understanding is that the primary benefit of the plea agreement here was not the dismissal of additional charges. There were charges dismissed, but it's essentially he pled the 2 counts of first-degree CSC, and the original 2 counts were dismissed. The difference being that he pleaded guilty based on the relationship variable instead of the age variable, which takes the 25-year mandatory minimum out of play. Certainly not arguing that he didn't get a benefit to his bargain, but I do want to make it benefit to the bargain, but I do want to make clear what that benefit was. It was not that there were a whole bunch of additional charges. It was that this was treated as a relationship case and not as an age case, which has significant ramifications for its mandatory minimum. That being said, we only have evidence of 2 penetrations. In order to score OV13 at 50 points, you need 3 penetrations. OV13, especially if we're relying on the preliminary exam transcript, is misscored and needs to be rescored appropriately. And that being the case, I'd have to look at it. I believe the appropriate score would be 25 points. Before I quote me on that, I'd want to take a quick look at that. As far as OV4 is concerned, there is absolutely nothing in the preliminary examination transcript in which the complainant says that she suffered any sort of psychological injury. And it is well established in case law that even if a reasonable person would look at this, a victim in this victim situation would surely suffer a psychological injury. That in and of itself is not enough to score OV4. There actually has to be some evidence that a psychological injury was suffered in this case. And there's nothing in the preliminary examination transcript. The only other thing that we have that was referenced during the prosecution's argument was that there was a statement made during the prosecutor's allocution saying that there was psychological injury. Allocution is not evidence. So in order to find something by a preponderance of the evidence, there needs to be evidence. Allocution is not evidence. An offer of proof is not evidence. Preliminary exam testimony would be evidence, but there's nothing in the preliminary examination transcript of psychological injury. And therefore, OV4 is. One other thing I do want to point out is in terms of the plea withdrawal motion, the argument was made that in order to succeed on a plea withdrawal motion, there has to be some defect in the plea taking process. And I will say that the majority of times when I have filed a motion to withdraw a plea after sentence, I usually am arguing that there was some specific defect, that the judge didn't say this or the judge didn't say that or whatever the case might be. However, it is established in case law that ineffective assistance of counsel can be the basis for finding if counsel's performance was, if the deficiency in counsel's performance caused a defendant to enter into a plea that was not voluntary, understanding, inaccurate, and any one of those things is missing, then that renders the plea invalid. In order to be valid, a plea must be voluntary, accurate, and understandable. And in this case, our ineffective assistance of counsel claims comes down to the fact that this plea is not accurate. Mr. Barker denies his guilt. He has denied his guilt all along. And if he did take a plea, it was for the purpose of mitigating the harm, the potential consequences. But that doesn't, just because there was some benefit to the bargain received, doesn't make the plea more accurate, doesn't negate the fact that Mr. Barker maintains his innocence and always has, and doesn't mitigate the fact that the appropriate way of resolving that sort of dispute is by holding a trial. And so Mr. Barker should have had a trial. Competent trial counsel would not have walked somebody to a guilty or no contest plea as they steadfastly and repeatedly maintained their innocence. And for those reasons, I believe he is entitled to a new trial. In the event that the court disagrees with that, he certainly is entitled to resentencing. And I would ask for resentencing if the court is not inclined to a plea withdrawal and a trial.
So you're claiming that his right to withdraw the plea is from the ineffective assistance of counsel, correct?
Well, I've made two arguments. One is ineffective assistance of counsel for walking him to the plea, and I believe that is, or for having him plead when he maintained his innocence. And I believe that the appropriate, and I do need to correct myself, I believe the appropriate remedy for that would be for the court to conduct a Ginther hearing, because I think the court needs to receive evidence from Mr. Barker and from trial counsel as to what conversations happened outside the presence of the court. The other argument too comes down to the representation as to what the guidelines would be and what Mr. Barker believed the guidelines to be at the time he entered his plea, which I don't think we would need to have a Ginther hearing for that, because I think the record speaks for itself as to what representations were made.
So what are you proposing this Ginther hearing would show?
I believe that a Ginther hearing would show that Mr. Barker repeatedly told his attorney that he was not guilty of these offenses, that he didn't do it, that this complainant was not telling the truth, and that and that nonetheless trial counsel advised him to enter into this no contest plea, knowing that entering into this no contest plea was perpetuating a fraud on the court, because Mr. Barker did not believe he was guilty and was in fact quite adamant that he was not guilty.
I would think that if he was that adamant about it, he would have raised that issue before or during the plea taking and let the court know.
All right. Do you have any case law regarding that issue?
I do not have case law to cite to the court right now. If the court is willing to entertain additional briefing on it, I would certainly be willing to provide that to the court if I can find anything in particular. But I don't have case law with me right now.
All right. I think basically on that issue, I think I would want some additional briefing, case law showing that a maintaining of innocence is worthy of ineffective assistance to counsel, even though a counsel is advising someone to take a no contest plea. If there's anything specific in that area. I'm sure that basically it has to look at the issue of, and how that considers the issue of having a preliminary examination where the victim testified to those transgressions, those penetrations. Because at that point, the trial becomes an issue of he said, she said. So I don't understand how that would affect the ineffective assistance of counsel at that point. So I think I want some briefing on that. Basically, then you're admitting that the plea was taken properly according to the court rules. Mr. Barker was informed of his rights. It was voluntary, freely and knowingly done. And then the only issue that I can see you have is having this ineffective assistance counsel, that why the counsel would have advised him to take a plea at that point, and whether or not that was effective assistance of counsel. But then you got the second prong of that is that the attorney's performance fall below the objective standard in advising his client to take a plea while he's maintaining his innocence, and is that below the objective standard of reasonableness. So that has to be addressed in that brief too.
Okay.
And then whether there's a reasonable probability, but for that deficient performance, the outcome would have been different. Clearly, what you're saying is that the counsel should have took it to trial. He could have been convicted. He might not have been convicted. If he would have been convicted, the penalty would have been a minimum of 25 years in prison. So I don't know how you can show that the outcome would have been different when you don't know what the result would be.
Your Honor, if I may, in the context of plea withdrawals, the different outcomes prong only requires a showing that had counsel's performance not been deficient, that the defendant would not have entered a plea. It does not necessitate a showing that that the defendant would have been acquitted at trial, and I will certainly provide case law.
And I'll grant you that, and I don't know specifically if there's some case law involving an attorney advising somebody to take a plea when they're maintaining their innocence. That's going to be the case law that I'm really interested in.
Okay, and I will do my research on that. I will say that without not being able to cite cases right now, I do know the case law is very clear that the prejudice prong is met if the defendant can show that he would not have entered the plea but for the deficient performance, even if he would have been otherwise found guilty at trial. So I will brief both of those issues, but if the court's granting additional time for briefing, I will focus on the first Strickland prong, which is the
third. I would like you to respond to the prosecutor's rebuttal brief, especially when she points out in page 15, the victim's asked how many times this occurs. She says 6 or 7. And how that would not be a factual basis for scoring.
Okay, and I do have an answer to that question, but I will save that for the briefing that the court's asking for.
Okay, yeah, because I think you're right. I haven't found anything, and I'll reread these briefs, but I haven't found anything where the victim has testified or stated anything in her words other than the prosecutor making a statement about the psychological. And there doesn't appear to be any victim's impact statement. If there is, maybe the prosecutor should get that brought up and distributed to all the parties. Okay. Any other questions, Mr. Kershaw?
Nope, at this point, I just want to summarize what I understand the court is saying is that you'd like supplemental briefing on the issue of whether or not having allowing an innocent, a client or defendant who claims to be innocent plead no contest, whether that falls below an objective standard of reasonableness. Also, the second Strickland prong as to whether or not what would need to be shown in order to show that the outcome would have been different, and to respond to the statement that apparently in the preliminary examination, the complainant said it happened 6 or 7 times, and how that relates to the scoring of OV13.
I believe that's it. Any questions, Mr. Webb? Because you're gonna have to file a rebuttal brief in that regards.
No, Your Honor, I'd just like to know what the timelines are.
Well, how much time do you want to do this? 30
Your Honor,
days?
well, what I was going to ask for is if there's any way that I can order a transcript of today's hearing. That way I can review the arguments that were made today as I'm going through, as I'm preparing my briefing, and then have the supplemental brief due maybe 21 days after the transcripts are prepared.
Court will grant that. The court will make sure that there's a transcript ordered. Okay?
Okay.
Yes. And you will have 14 days to respond to their brief. All right, so prosecutor will have 14 days to respond to yours, okay?
And I get 21 days after the
After you receive the transcript.
Okay. And I don't know if the court's able to facilitate this. Is it possible that I could have just a brief 5-minute breakout with Mr. Barker just to make sure he and I are on the same page and he understands everything that went on today?
Yes.
Okay.
All right. All right, we're in recess.
55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. On the case of People versus Tyler Kane Williams, counsel identified for the record, please.
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Good afternoon, Your Honor. Gerald White representing Mr. Williams.
You are Tyler Kane Williams?
Yes, Your Honor.
All right. Previously, you appeared in court and pled to the charge of police officer fleeing in the 3rd degree. That's a felony. It carries a maximum penalty of 5 years in prison. And you also pled to the charge of police officer assaulting, resisting, or obstructing, a felony that carries a maximum penalty of 2 years in prison. The minimums are discretionary with the court. A pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 9 months. Mr. White, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert?
Not at all, Your Honor. No.
Any objection to the scoring of the guidelines?
That appears to be accurate also, Your Honor. Thank you.
Mr. Webb, on behalf of the people.
Thank you, Your Honor. I've reviewed the report. I have no additions or corrections to make to it, and the guidelines are correctly scored.
All right. Mr. Williams, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
All right. Mr. White, on behalf of your client.
Your Honor, I would indicate for the court that I would, after having reviewed the pre-sentence investigation report made up by Ms. Medley, I would ask the court to follow the recommendations in that report. And there has to be an adjustment to the jail credit time because the sentencing was supposed to occur on this matter back in February 22nd. And so it's now May 25th. So there's quite a few days to be added to the jail credit.
All right. So, but the court gave him a PR bond on the 22nd of February, so he could get over to some of the other courts to get those things settled. but I will point, so I think the jail credit is correct at 125 because the time he's spending in those other jails are for those jails. The agreement is for the sentencing at bottom of guidelines, so it's not gonna matter much.
Correct.
Guideline bottom is 0.
I agree, Your Honor. Mr. Williams was sentenced to 6 months in jail at Roscommon. He was serving at the present time.
Mr. Webb, any elocution?
No, Your Honor, I just asked you to follow the plea agreement and the recommendations from the probation department. I had an updated PSI report in our file that showed as of April 26th, I think was another sentencing date, he had 188 days credit. But I'll leave it to the court or the probation department.
Yeah, I know that's what the probation department did, except that if he's out on PR bond, he's not getting any credit. So it's pretty simple. Even though he's doing jail time in another jail, but that was, we gave him the PR bond so he could get over there and take those, get those matters taken care of. Court has reviewed through the pre-sentence investigation report, does provide for sentencing guidelines of 0 to 9 months. This is an agreement for the Briggs Killebrew cap at the bottom of the guidelines, which are 0. In order to punish you for what you've done, to attempt to rehabilitate you, to deter others from committing similar acts, is going to be a sentence of this court that you be placed on probation for a period of 2 years, along with the statutory terms of probation and the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter into places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must complete outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. Court's going to order you to do 100 hours of community service. If you successfully complete those 100 hours, court will reduce your fines and costs by $600. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you're first obtaining written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends, and holidays accepted. You must not have any verbal, written, electronic, or physical contact with Crystal Beeston, either directly or through another person. Court's also going to make it that you should be in your approved residence between the hours of 11 p.m. and 6 a.m. unless excused in writing by the field agent. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. Court's not going to send you any jail time. You do have credit for 125 days served. You must comply with DNA testing, pay a $60 fee, pay $136 in state costs, pay a crime victims assessment of $130. Court's going to say that you have to pay a supervision fee of $30 a month or $60 a month when supervising electronic monitoring. But if you're on probation in another county and they're charging the fee, then we're not gonna charge it. So he only needs to pay one supervision fee, depending on which county is doing the supervision, I think. Would be appropriate. You must pay $500 court costs, a fine of $500. How much are you charging for attorney fees?
$650, Your Honor.
$650 in attorney fees, court-appointed attorney fees. Probation officer of this court or any other supervising agent may pursuant to MCL 771.4 apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. Must not be in the same residence of any individual. Actually, that one is not going to apply. But you're not allowed to use recreational marijuana or grow any recreational marijuana. And you're not allowed to be around other people who are using recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from the field agent. You must set up an installment payment agreement with the Clark County's clerk's office within 30 days of your release from jail. And there's been no request for restitution at this time, Mr. Webb?
Not that I'm aware of.
And restitution will just be left open for 30 days to see if anybody submits some. Unfortunately, the way the law is, they can submit a restitution request a year from now and we have to still order. So if there is any restitution, Mr. Williams is going to have to pay it at some point. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate's rights form when it's given to you. Mr. McConnell, do you need to talk to him today at all?
Thank you, Your Honor. Mr. Williams, if you're released from jail, you need to contact Agent Medley within 24 hours. Thank you, Your Honor. Nothing further.
Mr. Williams, do you think you'll be, where will you be living when you leave the jail there?
At my father's house, I hope.
And where is that located?
St. Helen.
Okay, all right. So there may be appropriate to have him supervised out of Roscommon County.
Yes, Your Honor. Thank you.
Okay. Anything further from anybody?
No, thank you, Your Honor.
Well, thank you, Your Honor. Thank you much.
Good luck, Mr. Williams. We are in recess.
Thank you, Your Honor.